You are watching PR English Shorthand Dictations YouTube channel.
This is English Shorthand dictation number 378 and the dictation speed is 120 words per minute. Ready? Start. We have meticulously perused the materials on record and considered the contentions advanced at the bar with the care and attention the same deserve. In cases of the present nature, where material witnesses are withheld by the prosecution, and it is the positive case set up by the defense that he has been falsely implicated for murder, though death of the victim could be for reasons attributable to an accidental fall from a tree, and such a case in defense finds some amount of corroboration from the other evidence on record, coupled with the fact that the appellate court has imposed a lesser sentence upon reversal of the finding of murder returned by the trial court. This court, as the court of last resort, has a duty to separate the grain from the chaff, and after sieving the untruth or unacceptable portion of the evidence, to also examine whether the residue is sufficient to prove the guilt of the accused. There seems to be no legal bar in convincing an accused resting on part of the evidence which is primarily found to be credible and acceptable. However, where the evidence is so inseparable that any attempt to separate them would destroy the substratum on which the prosecution version is founded, then this court would be within its legal limits to discard the evidence in its entirety. Bearing this settled principle in mind, we proceed to assess the evidence on record. We start with the FIR to which exception has been taken by the appellant, urging that there has been no satisfactory explanation for its belated registration. It is trite that merely because there is some delay in lodging an FIR, the same by itself and without anything more ought not to weigh in the mind of the courts in all cases as fatal for the prosecution. A realistic and pragmatic approach has to be adopted, keeping in mind the peculiarities of each particular case to assess whether the unexplained delay in lodging the FIR is an afterthought to give a colored version of the incident, which is sufficient to corrode the credibility of the prosecution version. In cases where delay occurs, it has to be tested on the anvil of other attending circumstances. If, on an overall consideration of all relevant circumstances, it appears to the court that the delay in lodging the FIR has been explained, mere delay cannot be sufficient to disbelieve the prosecution case. However, if the delay is not satisfactorily explained and it appears to the court that cause for the delay had been necessitated to frame anyone as an accused, there is no reason as to why the delay should not be considered as fatal, forming part of several factors to vitiate the conviction. We have heard the learned counsel appearing on behalf of the appellants and the learned counsel appearing on behalf of the respondents. The learned senior counsel for the appellants submits that the reasoning given by the division bench of the High Court is totally perfunctory. He submits that the learned single judge, by an elaborate, well reasoned order, found that the writ petitioners were not entitled for absorption. He further submits that, as per the scheme, four conditions were required to be fulfilled, and the writ petitioners did not comply with the said conditions. Finding this, the learned single judge dismissed the writ petition. He submits that the division bench, however, on a ground that the report of the committee was signed by only one member and not all the three members, has erroneously reversed the well reasoned order passed by the learned single judge. He further submits that the personal affidavit filed by the additional chief secretary of the state government dated 6th December 2022 would reveal that the report of the committee was accepted by the cabinet of the state of Bihar, and as such the reasoning that the report was not signed by all the three officers is totally without substance. The learned senior counsel for the respondents' employees, on the contrary, submits that the writ petitioners have been continuously working from 1999 till 2017. He submits that the writ petitioners have continuously worked for a period of almost 18 years. He submits that all the writ petitioners complied with all the four conditions as stipulated in the scheme of 2012. He further submits that the learned single judge in the first round of litigation has also found that the writ petitioners complied with all the four conditions. In the peculiar facts and circumstances, we are not inclined to go into the legal issues. At the outset, we may say that we are not satisfied with the manner in which the division bench has dealt with the matter in the present litigation. When the division bench was considering the well reasoned order passed by the learned single judge, the least that was expected of it was to give reasonings as to why it disagreed with the findings given by the learned single judge. Insofar as the finding of the division bench that the report was not signed by three members is concerned, it ought to have taken into consideration that much water had flown subsequently, inasmuch as the affidavit of the additional chief secretary dated 6th December 2022 would have shown that the report of the committee was accepted by the state government, which was fructified in the scheme dated 12th July 2012, which was published in the Gazette notification. As such, the High Court at the most could have examined the correctness of the scheme as notified in the Gazette notification. It appears that the division bench found an easy way to deal with the litigation. In any case, if the directions as issued by the division bench are to be complied with, it will lead to more than one complication. The division bench has granted liberty to the state government to again start the process and, in the meantime, directed the writ petitioners to be taken back to work. It has further directed honorary benefits to be calculated and disbursed for the intervening period. We are of the considered view that if the order, as passed by the division bench, is permitted to continue, it will give rise to third round of litigation and would not provide any solace to the employees who have been fighting for justice since 2017.